Welcome back to another episode of Taking Inventory. This week, we've got Adam Greenberg. Adam's been the general counsel at a number of high-growth startups like Warby Parker, Row, and Blank Street. Adam, super excited to have you here today. Let's just jump right in and talk about you making the move from big law at Skadden to then joining Warby Parker and then some of the roles you've held since then. Let's just start there.
Sounds great. Hey guys, good to see you. So yeah, I started my career at Skadden Arps in the New York office. Did a year of litigation, high stakes, bet the company litigation. Took a year off from the law firm to come back to LA to do a clerkship for a federal appellate judge on the Ninth Circuit, kind of acting as a mini judge for a year, supporting my judge, and then got a bit burnt out on litigation after a couple years and wanted to try my hand at some transactional law. So rejoined Skadden and did a few more years doing a mix of real estate transactions and IP and tech transactions. Pretty early on in my time at Skadden, I came to the conclusion that long-term, the big law career wasn't for me. It's for some folks. It wasn't for me. And primarily, the reason was I wasn't feeling super connected to the companies that I was representing and what was actually happening at the businesses we were representing. We kind of would parachute in for a big litigation or a big transaction and then parachute out when it was over. And I personally was much more interested in the building and what was happening within the companies we were representing. So kind of made it my mission to get an in-house job in the tech world and startup world in New York City, and was really fortunate to get hired as the second lawyer at Warby Parker in 2014. The job description, I think, said we were looking for someone with some litigation background, some real estate background, and some IP and tech background, which just luckily for me, I had hit all three of those groups at Skadden, and it just worked out perfectly for me.
And when you went there, I mean, I know kind of like I use Warby Parker for like all my glasses, and it's like I get my prescription done with that thing where you stand 15 feet away from it. It's like, it's insane. Obviously at this point, like none of that stuff was there. And so like, how do you even start going after these regulated industries and how regulated is like the eyeglasses market? Like it's fairly, right?
Yeah, surprisingly, yes. The practice of opticianry, which are the folks that when you go into a Warby store or another optometry store or eyeglass store, are fixing your glasses, making sure it's the right fit, making sure you see well out of them. In many states, that's a regulated practice. Not as heavily regulated as like being a doctor or nurse, but it's a regulated practice. That's something we have to keep in mind as we rolled out our brick and mortar strategy. On the remote vision test, that was something that in my last year or two at Warby, I was intimately involved in and part of a kind of a small team that was helping develop that. I wasn't developing anything as a lawyer, but what I had to do was, as a telemedicine product, quickly had to get smart on how telehealth was regulated at a state by state level. Primarily, when you're talking about telemedicine and you're outside of the Medicare, Medicaid context, you're looking at state laws and regulations. Back in 2018, when we were working on launching this, the laws weren't even nearly as mature as they are today. State governments were trying to figure out what to do with telehealth, how to regulate it, what's good, what's bad in it, pre-COVID, but certainly since COVID, that has accelerated in every state, and it's constantly changing. So I think what was most interesting about that time at Warby was soon before we launched the first version of that remote eye exam. It was a pretty cool product using your phone and your computer. It's evolved since then to be even cooler and faster and easier to use. But before we launched, the optometrists, which are surprisingly a really strong political lobby across the country, they caught wind of the new tech that we were going to release, and went state by state trying to pass laws that would effectively outlaw the new technology. The business model for a typical optometrist is get you into their office, do an eye exam that's fairly affordable, and then walk you into their eyeglass shop, which is attached, and sell you a pair of glasses, which are on average high hundreds, low thousands of dollars. Not getting the patients in their seats, instead allowing them to do an eye exam remotely, really threatened their bottom line. I hadn't done any lobbying, being a corporate lawyer at Skadden, I really didn't know what I was doing, but had a small budget, and the founders were like, "You're the most natural person at the company to go handle this. So, good luck. Go do your best to try to get these bills killed." And I traveled state to state capitals for the better part of a year, talking to legislators about telehealth, about remote eye exams. It was a really awesome experience.
Were the legislators like receptive at all? Like, were they like, "What are you talking about, man"?
They were. I was surprised. I think federal lobbying is a much different beast. Takes a lot more money, and you need to be kind of a much bigger fish in the pond to get folks' attention. The state level, I was surprised by our ability to access legislators and have open dialogue with them about it. And it felt like much more of a comms and a sales kind of job than a legal job. We would be talking to folks on both sides of the aisle, Democrats and Republicans, and your story and narrative changes based on what state you're in, what their political affiliation is, and what resonates personally with that individual legislator.
How does that work? Like, are you just finding the legislators that you're like, yeah, these are the ones we need to talk to. These are the heavy hitters in this state or district, and like, let's cold call them? Do you have outside consultants? Like, what is that even? You figured it out, but like, where'd you even start?
So I learned pretty quickly, and this was super helpful to me. There's a public database. If you hire a lobbyist in a state, that's public information, which company hires which lobbyist. So I would just go to the databases in the states where we thought there was the greatest risk, or the states that were most important to the company financially, and see who the lobbyists were that were representing like-minded companies that were disrupting industries, that were operating in gray regulatory areas. So I'd see who were the lobbyists representing Airbnb, Lyft, Uber, Amazon, and I would cold call them. I'd say at that point, when I first started at Warby, not everyone knew who we were. At that point, we were a pretty well-known brand, so at least folks were picking up the phone and interested in the conversation. But I'd interview a few folks in the state. I'd get a sense of how they work, what their strategy might be, and would hire them up that way.
It's such a we'll get into where you went next in your career in a minute, but we'll stay on Warby. But that seems like it's pretty relevant for the experience at Rowe. For Warby, like, you guys at the time, at least, we always kind of, and we were doing a bunch of like Facebook ad stuff back in the day, but we always looked at you guys as being like one of the most sophisticated marketers. Like, that growth team, I think, was considered to be like one of the best, like, in sort of all of e-com. And what was that like? I guess, like, from advertising these like highly regulated products, like getting alignment with the rest of the team, and also like you trying to be like supportive of the organization and not like the lawyer who like has to like kind of knock everything down. Like, what was that kind of dance like?
A lot easier at Warby than it was at Rowe. We weren't advertising prescription products or even vitamins. Advertising prescription eyeglasses, generally less regulatory attention, less risks around what you should or shouldn't be saying. So the marketing team and the growth team there were incredible. I learned everything I know about that from them, and really loved partnering with them. But there weren't a lot of constraints in that. Once we got into the remote eye exams, and were advertising telehealth services from eye doctors. Came a little bit different, but the core product line, there wasn't much limitation on marketing there.
Were you also like, as obviously this growth team is helping build a business, but like I think you were involved in like 6 rounds of funding through the IPO. Like, what was that process like as you guys continue to get bigger, talk to really big investors, and then preparing for an IPO? Yeah, what is that like from your perspective?
There was a lot of stuff to juggle. My role during the fundraising, and prior to Warby, I hadn't done much venture work or much financing work. So I was learning as I was going and leaning really heavily on super smart and experienced outside counsel. My my role during those was really to know the business through and through for diligence purposes. So when investors or their lawyers had questions about how the company was operating, what the risks of the company were, what the regulatory landscape looked like, how we were complying with any number of laws and regulations, consumer privacy, healthcare, I knew it. As well as anyone. So that was really where I contributed in that process, and then supported and managed outside counsel as they were going through the negotiation of the fundraising documents.
Yeah, and the outside counsel one is one that we've always found to be interesting. And I didn't really understand that dynamic until I got to Snap, where like you had some amazing lawyers there, a ton of incredible lawyers, but then like they always had access to outside counsel, and I never like quite understood like the dance between how like when do you kind of go outside and not, like what is that, what's like the strategy there, and we have a lot of because of obviously one of your good friends and our co-founder Sean Friedland, we have a lot of lawyers at ad platforms that listen to this podcast, and kind of curious if you have advice for like how you're supposed to approach sort of that and how you move back and forth.
Yeah, as a general counsel, I've intentionally styled my career very much as a generalist, like the title says. So I can go medium depth on a whole lot of issues, but over the years and being in house as a GC for about a decade, you kind of build an instinct of when you've reached your limit and when an issue is important enough where you need to stop and go spend some money getting advice from outside counsel. There are key areas where I feel like I'd be doing a disservice to the company or even malpractice if I tried to handle them on my own. Those are things like litigation, typically handled by outside counsel, patents, a really technical area, tax, fundraising, corporate. My goal was to surround myself, especially as a younger GC that was still learning the ropes of how to do the job, was to surround myself with really experienced outside counsel who were best in class in their particular or narrow category. I think some companies, especially that don't have any internal counsel, they will rely on one or two law firms for everything they need, for litigation, IP, employment, corporate, contracts, because administratively it's just a headache to be managing so many different firms. When I got in house and I took that work off of the non-lawyers' plates, my approach was kind of the opposite. I wanted to find the person who is the best in that particular category, who can give me practical advice, who's seen so much across the space that I can call when any number of questions that I'm being asked for the first time, which still happens to me on a daily basis, questions I've never heard before, I'm not sure where to begin, where I can call and say, hey, is this a big deal? How worried should I be about this? And what's the best approach to get an answer? So at any given time, at Warby or at Rowe, was managing a bench of 10 to 15 law firms. Administratively, more challenging, but I felt like I was talking to people who really knew the space the best.
And then maybe on the inverse of that question, because I think a lot of folks that listen, are entrepreneurs, startup founders, or have kind of growth companies and are working primarily with outside counsel. When is the right time to start thinking about bringing an attorney in-house and actually building out that discipline?
That's the big question. I hear that a lot. I think if you're looking at bringing in internal legal as a means to reduce spend, it's probably not the right framework to be thinking through, because there are ways to reduce spend by having part-time lawyers, going to smaller law firms, working on a project or flat fee basis. I think you want to start looking at bringing a general counsel as a legal executive in-house when you feel like legal needs to be a strategic member of the executive team helping set the strategy of the company. And that typically happens for not heavily regulated industries. I tend to see it mostly around the Series D stage when companies are getting a little bit more mature. They're having some discussions about an exit, whether that's an acquisition or an IPO. There are more employment issues to deal with. There's more potentially litigation issues if they're a consumer brand, consumer compliance or consumer litigation. If you're a regulated company in healthcare and fintech, probably a bit earlier than that. It's good to get a leader in the seat who can give that early and often advice as you're thinking about what products to roll out, what strategies to unroll. Having that person who's just around and in those conversations to be giving that early advice, say there might be some issues here. Maybe we think about launching the product in this way instead of that way, and that will reduce some risk. What you really want to avoid is the product and engineering teams get in a room, have all these great ideas, put a plan together, start building it, and then upon rollout, you're uncovering a host of legal or regulatory issues that might get you in trouble and really hurt growth in the future. So the earlier you can get some legal input, whether that's from your in-house counsel or outside counsel, the better.
And just talking about regulated industries, I guess Roe is probably I assume one of the more regulated companies in the country in terms of I guess especially ones that have succeeded. I've talked to you about this, just in the past about that team. I don't want to put words around it, but that team is incredible from all things I've heard, and they're doing something much bigger than even I think people sort of understand. Can you just give listeners, before we kind of get into your work at Roe, just what Roe really is, all the things they do? Because I think there's probably even a misconception about how big of a business that thing really is.
Yeah. It's a lot of things. And we're working on a lot of different, really exciting products at the same time. It's at its core, it's a direct to consumer digital health platform, a place where you could access, or a consumer who is looking for help on a wide variety of health issues, can go to the platform, access the services of a provider, a doctor or nurse, potentially get prescribed medication, and then a few days later get that medication on their doorstep. That's the simplistic description. There's also a lot more that the company does. Then there's an over-the-counter business, medical device, and since I left the company, they've been investing really heavily in weight loss and obesity management. But when I was there, when I first started, the company was then called Roman. Now the broader platform is called Roe. The men's health brand is still called Roman. The company was mainly focused on men's health. And in my 4 years there, we rolled out women's health products, dermatology, weight management, mental health, over-the-counter and acquired 4 health tech startups. So there's a lot of really exciting activity during my time there.
And the founders it's a father and son, right?
Three original founders. The founder CEO, Zach Reitano, his father is an advisor and a close consultant to the company, but wasn't one of the original founders.
How do you, like, what you just described is like, if it wasn't healthcare, that's a tech startup. The speed at which you guys are moving, the number of acquisitions, number of products you're rolling out, like how did you partner with the company to move that fast in such an industry that is so highly regulated and traditionally moved so slowly because of the risk associated with it?
And not break laws and get everyone to like you.
That last part is harder. There was a lot of work that went into that part. I got really lucky. Zach, who's the co-founder CEO, from the earliest days when I joined, made it clear to me that he wanted to build a best-in-class legal function at the company, and I really love that philosophy and that approach. I think you'll find some startups who look at legal as a cost center, a necessary evil of doing business, and a place where you just want contracts done or things approved. I was really fortunate to be at a place that looked at legal as a strategic asset. So I had a lot of support from the early days to build a best-in-class legal team. Not being a health regulatory lawyer, certainly have spent some time in it when I was at Warby, but not being like a true healthcare lawyer. My approach was to surround myself with other lawyers on the team and bring in lawyers on the team who really knew that space a lot better than me, that I could learn from, and hired some really incredible attorneys that some from in-house, some from outside counsel, who could be true partners to the business. And one of those strategies we did to ingratiate legal into the rest of the business, and really make them feel like they're part of teams, was to embed certain members of my team into other teams. So into the marketing team, growth team, product, engineering, medical operations. So they're going to weekly stand-ups, they're part of ideation sessions, and they really feel bought in, that they're part of the team, to help facilitate growth and launch products, not to be there as a police officer, right, trying to catch people doing the wrong thing, but quite the opposite, actually helping facilitate the growth of the company.
Yeah, I mean, I think that's an interesting, I think, framework to think about, where you're actually embedding in all these individual teams. Because I think, like at Snap, it wasn't quite like that, but there were certainly privacy lawyers that were attached to certain teams and had a really good understanding as products continued to develop. Is that kind of a modern way of creating a legal team framework within a company, or is that something that you've seen? I guess, how can companies think about building something similar but retrofitted to their organization?
I do think it's a more modern way of looking at the legal function internally. Historically, GCs were thought of as the protector of the realm, right? Just protect the company against risk. I don't think that works in a fast-growing tech company or in the startup world. I think it has to be both things. It has to be figure out what the risk tolerance is and help set the company's risk tolerance and be prepared for risk, but also use, especially in regulated industries, use your knowledge, your skill sets, your connections in the regulatory space to creatively push growth forward and push products forward. That's a newer way of looking at the function, and I think it's the right way. It's the way that I look at it as well, because you guys probably have this experience from Snap. If you have a lawyer in the room who's just saying we can't do that, we can't do this, that lawyer's not going to be invited to meetings. That lawyer's probably not going to last very long at the company. So you have to be creative in the advice you're delivering, and only in rare situations, and this has been true of my career too, can you really use that trump card where you say, guys, there are serious issues here. We're facing an existential risk. We're facing crazy financial risk, or in rare instances, criminal risk, where you could say this is not something we should be pursuing. Instead, what you need to do is work with the teams, the business teams, figure out the right way to do it, where you're meeting your business goals and you're not putting the company in too much legal jeopardy. And the key is, I think, is the GC partnering really closely with the rest of the leadership team to figure out what that risk tolerance is. How much are we comfortable with?
And we were talking about kind of the marketing side with Warby, but for Row, just given like all the different products and obviously like just a complex sort of regulatory framework for all those things, how do you approach that? Is that one of those things where like you it is more binary with the teams? Like it's like unfortunately you just can't make that statement. Like how does that back and forth work?
Rarely is it you can't make that statement. It's more about, if we make this statement, here's what's likely to happen, and here are the potential consequences. Especially in regulated spaces, um, you can spend all of your resources and all your time trying to get 100% compliant, and you're still not going to get there. So the key is really figuring out where are the most material risks. It's and then what are the business priorities, and then working towards that. What I like to do, whether in a regulated space or not, try to figure out, okay, if there's a technical violation of a regulation, or a very clear violation, then what? What's the practical impact of it? Is that going to be um, a confidential private conversation with the regulator where you negotiate a change of practice? Is it going to be a really expensive and noisy public dispute and litigation? Is it going to be a small fine, slap on the wrist? Or is there shutdown potential, right? That, like, kind of worst case scenario, your business or your product line gets shut down. That's really important. And every founder I've worked with immediately goes there with that question. So the prepared in-house counsel, the prepared GC has already done that legwork, has already done that research, has talked to outside counsel, industry associations, friends in similar industries, to figure out what's the practical impact on a regulatory violation or investigation, and is the company comfortable taking on that risk.
I mean, as you're setting that up, I mean, it is kind of a funny thing to think about. Like, it's like you don't want to be batting 1,000 of like never getting in trouble, right? You do sometimes want someone to be like, you're pushing the limit a little too far. And so, like, as you're, I imagine, like, negotiating with your business stakeholders, are you providing those recommendations of like, I think we can push it this far, or are you kind of just laying it out and saying, here's what I am as a lawyer I'm comfortable with, but like, here's the boundaries of what you as the marketer can do?
I think that's the key difference between being in-house versus outside counsel. Outside counsel, you're really advisory. You're saying, here are your options. Here's what I think is going to happen. Here are the risks associated with those options. Choose your own adventure. In-house, you don't have that luxury. You're looked to by the leadership team and the board, to have a point of view and say in the room, here's what I think the company should do. I really like that. Some lawyers prefer the more advisory role, outside counsel role. I like being in the mix and helping make decisions. I'm not always right. You're operating on a heightened timeline, expedited timeline, with imperfect information. But that's a lot of the fun in the job is being in the mix and making those decisions without knowing exactly how they're going to turn out.
Yeah, and one area that you mentioned earlier that we just wanted to pick your brain on too is just, what is like the GC's role in these acquisitions? Like we've been fortunate to sell some companies, and then we've bought a few, and I'm always kind of like I remember the first time I was involved in one. I remember an advisor of mine, like we had to go get like the more expensive law firm to rep us because he's just like, the other side is going to just judge us on who we have. And so, what is it from like the GC's point of view of how you're looking at these deals? How much like are you involved in deciding if it's a good idea? And like, is there any good advice out there for people who are trying to sell companies and make sure that the GCs on the other side are more likely to go along than not?
Yeah. My advice would be to get the GC. If you have a GC, get the GC involved as early as possible before term sheet. When you're considering, especially if you're in a regulated space or a consumer space, and there are those risks involved. And that was my experience, thankfully, at Row. When we were looking at companies, of whether we acquired them or not, I would get involved pretty early on to do some initial digging around their space, some of the risks in the space. Is it heavily litigious? What do the regulators think about it? And give some early feedback. I wasn't often asked my advice. Should we do the deal? Should we not do the deal? Sometimes I would give it, unsolicited, because I had an opinion. But I wanted to set the corp dev team up and the founders up with as much information as possible around, okay, if we acquire this company, what's the lift to get them to a place from a legal and regulatory or compliance perspective that we're comfortable with? And what are the longer term risks of operating and running this business? And then post term sheet, very actively involved in diligence. I was fortunate to have a pretty robust legal team at Row, so we did a lot of the diligence ourselves internally. Would rely a little bit on outside counsel for highly specialized areas like FDA and HIPAA. And then throughout the acquisition, mostly supporting and managing outside counsel, trying to take as much off the plate of the corp dev team and the founders, so they don't have to be spending a lot of their time negotiating documents and looking at documents. And then post acquisition, pretty involved in the integration process as well.
That's super interesting, and it brings up another line of questioning I have. But I know you're busy, so as we look to wrap, I think we've spent a lot of this conversation talking about like legal as a defensive function of like protecting the company, minimizing risk, kind of doing all this stuff. But how about as an offensive function, like helping build the moat and protect the company from new competition? Like, what have you done, in your various roles to be a little more offensive to protect the company? And how do you think about the legal function, being an asset to helping differentiate the companies?
I think there are two key areas for providing offensive support. One is around IP, whether it's patents or trademarks. Having a really strong understanding of competitors, of the industry you're working in is critical for a general counsel. And I think GCs are kind of expected to not only know internally the business operations through and through, but what's happening in the industry. So monitoring the landscape, doing your best to figure out our competitors misusing our name, misusing our brand, potentially infringing on our IP, is one really important. And then enforce it, what to do about it if you do find some infringement. And then the other is around policy and government affairs, is especially if you're in an industry that's evolving, where the regulations are also evolving, is establishing yourself as a player and getting a seat at the table when regulators and legislators are trying to figure out how to make sense of your industry. And I really loved doing that proactive government affairs work when I was at Roe. Roe was one of the pioneers in direct to consumer telemedicine. Pre-COVID, like I said, laws were fluid, and governments were thinking about it. During the pandemic, it was an explosion of conversation around policy. So, we identified states that were really important to us and proactively would build those relationships, would go to Capitol Hill, explain all the great things we're doing, both for patients and for doctors, um, and just getting on their radar. So when a bill comes up or a policy issue comes up, we're on their speed dial to say, hey, Adam, there's this bill on my desk. How do I make sense of it? How does it impact your business? How does it impact your industry? And you can have a voice in crafting what the future of that policy looks like.
And is that like the congressperson's like chief of staff calling you, being like, I got to understand what's going on here?
Yeah, sometimes. So we would typically hire lobbyists defensively when a bill would get proposed that we think doesn't make sense, isn't helpful for consumers or providers, or not helpful for our business model. And we would show up and engage in conversation, either try to modify the language of the bill in a way that we think works for us, or try to get the bill killed altogether. Proactively, it's a little bit more of a longer game, and a longer relationship build, where you're trying to show the legislators and their staff that you're the leader in the space. You know what's going on in the space better than anyone else, and you are a good actor. You're really trying to provide value to their constituents, and bring jobs to their communities. And sometimes you're just on email threads with legislators themselves, and you're like, hey, you gave me your email last time I came to the Hill to meet. I just saw this bill introduced. We have some issues with it. Are you open for a conversation? We'd love to give you our perspective on it. I was surprised by the amount of access you could have. And some legislators are more open to those conversations than others. And it was interesting, both at Warby and at Roe. You kind of have to know who you're talking to, and what their, like I said before, what their political priorities are. And your message on the left might be different than your message on the right. In terms of telehealth, um, we were I was lucky to be in a space that wasn't incredibly controversial politically. There were some conversations that were outside the scope of Roe around abortion access through telehealth means, and access to drugs through telehealth. We were outside of that, but that was politically hot button issue in the telehealth world for us. On the left, when we'd have conversations, it was all about opening up access to underserved communities who might not be able to see a doctor in a brick and mortar setting very easily, and bringing down costs for patients. On the right, it was all about deregulation. We are working with doctors and nurses who have medical degrees and nursing degrees. They've gone through the school, they've taken the tests, they have the license. Let's trust them to do what they think is right with the license and provide the kind of tools, technology, and services that they think is appropriate for their patients. And let's not have the government tell them what they can or can't do with patients.
It's like fascinating. I mean, the whole conversation today has been like, it's like behind the veil of like these companies. Like we're so used to obviously just like building the tech and commercializing it, but I think it's not often talked about of like, how are these companies actually protected? How are they like offensively going to lobby outside of outside of customers and things like that? So it's super interesting to hear about. But before we let you go, if somebody wants to get in touch and learn more about the work you've done, or ask you some questions about maybe some things they're working on, where can they find you?
Find me on LinkedIn. Can email me. Can I give my email address? Is that
Yeah, go for it.
Yeah.
kosher here?
Yeah.
apgreenberg@gmail.com. Happy to talk through issues. I have conversations with startups and founders all the time about how they should be thinking about building a legal infrastructure. When is the right time to hire a GC? What's the right profile to hire a GC? So always happy to have those conversations.
Yeah. It's very cool. Yeah, this is like a first for taking inventory, this style of conversation. So congrats, Adam, on being the first, and thank you so much for joining us today.
Yeah, if your email blows up, then we did a good job promoting this.
Yeah, and don't spam it; he'll sue you. So
yeah,
it's hard to make legal interesting. So hopefully there's some kernels of interesting information here.
No, this is great, man. Thank you. We appreciate it, and thank you for building all these amazing products. It's very cool, the stuff you've done. Excited to see what you do next. Thanks, bud.
It was great to talk to you guys. Thanks so much.